All right, good morning, everyone. My name is Meredith Kessler. I'm an attorney with the Religious Liberty Clinic here at Notre Dame, and it is my great pleasure to introduce our panelists this morning, starting with our award winner, Tom Berg. Professor Tom Berg is the James L. Oberstar Professor of Law and Public Policy at the University of St. Thomas School of Law, where he teaches constitutional law, religious liberty, intellectual property courses, and a religious liberty appellate clinic. Professor Berg has written 6 books, 75 book chapters and journal articles, and dozens of opinion pieces on religious freedom, constitutional law, and the role of religion in law, politics, and society. This morning, we are honored to feature a panel discussion on Professor Berg's most recent book, which hopefully you've all picked up a copy of, Religious Liberty in a Polarized Age, which addresses the central theme of this year's Religious Liberty Summit: how to have conversations about religious liberty that may bring together both sides of the political divide. Last night, Professor Berg received the 2024 Notre Dame Religious Liberty Initiative Scholarship Award in recognition of this tremendous book. We will begin with remarks by Professor Berg, after which we'll hear contributions from our other 3 panelists about how we might promote and preserve religious liberty in this polarized time. I'll introduce all of our distinguished panels now, and then to turn everything over to Professor Berg. First, we have Elder Alexander Dushku, who's a General Authority 70 and General Counsel of the Church of Jesus Christ of Latter-day Saints, a worldwide Christian denomination of nearly 18 million people. Before his call to full-time church service in October 2023, he was a shareholder in the Salt Lake City law firm Curtin McConkie, where he for many years was head of the firm's constitutional and appellate practice, specializing in appellate brief writing and critical law and motion practice. He has authored numerous briefs in important religious liberty cases before appellate courts across the United States, including in the United States Supreme Court, and has consulted with legislators and advocates across the country on religious liberty issues. As a senior outside counsel for public policies issues for the Church of Jesus Christ of Latter-day Saints, he was a primary negotiator of the 2015 Utah Compromise legislation that received national attention for reconciling religious and LGBTQ rights. Next, we have Professor Asma Uddin, who is a professor, lawyer, and prolific author on the subject of religious liberty. She has written extensively on the topic of depolarization strategies, and her recent major publications include 2 books on similar themes: 2019, When Islam is Not a Religion, Inside America's Fight for Religious Freedom, and 2021's The Politics of Vulnerability, How to Heal Muslim-Christian Relations in a Post-Christian America, for which she received the Notre Dame Religious Liberty Initiative Inaugural Scholarship Prize. And she has also written extensively on the topic of depolarization strategies. She is currently visiting associate professor of law at the Catholic University of America, where she teaches family law, international human rights, gender, law and policy, and Catholic University's Religious Liberty Clinic. She has previously taught the Religious Liberty Clinic at Harvard Law School and served as legal counsel at the Becket Fund. She also serves on the board of advisors for our own RLI here at Notre Dame. And finally, to my right, Professor Robin Wilson. Professor Robin Fretwell Wilson is the Mildred V. Voorhis Jones Chair in Law at the University of Illinois College of Law, where she co-directs the College of Law's Family Law and Policy Program and its Epstein Health Law and Policy Program. Professor Wilson is the author of 20 books, including books on the intersection of religious liberty and LGBT rights. She is also the founder and director of the Fairness for All initiative, which seeks to provide tangible support and advice to policymakers seeking balanced approaches that respect both LGBT rights and religious freedom. Professor Wilson has worked extensively on behalf of federal and state law reform efforts, including the 2022 Federal Respect for Marriage Act, which she just mentioned, and she is the architect or advisor on more than 36 laws across the United States. Professor Wilson has received too many honors to name for her law reform efforts, including having been honored 3 times by the Utah State Senate for her work on anti-discrimination legislation that balances religious liberty and LGBT rights. Please join me in welcoming Professor Berg and all of our panelists.
Thank you, Meredith, and thank you, Stephanie and Marcus and everyone here at Notre Dame again for this wonderful summit and for the recognition that I've received and for all that you do. It's wonderful. I'm very gratified that the whole summit is about the topic of polarization because I'm interested in it, and it's a depressing subject to write about and research, but it's important. I am getting a bit of the sense, though, that polarization is kind of like what Mark Twain said about the weather, right? Everybody talks about it, but nobody does anything about it. But maybe we'll make some progress here today. So my book argument is essentially this. Religious liberty is meant to protect people from having to suffer at the hands of the government for living according to their deep beliefs about the divine, the nature of the universe, and how those affect the meaning and purpose of life. Since both religious practices and government are perennial features of society, that goal of religious liberty is perennial and current. So as I looked at our current polarized society, I was struck by the ways in which we are repeating, in a soft version, the habits and cycles of conflict that required the commitment to religious liberty in the first place. In Reformation-era Europe, civil rulers attacked Catholics, or attacked Protestants, or attacked one group of Protestants over another. Those attacked not only suffered, but became fearful and angry, and if they got control of the government, they'd seek to retaliate for past attacks or to attack the other side before it attacked them. The result, in James Madison's phrase, was that torrents of blood were spilt. Religious liberty was ultimately the solution. Equal and complete liberty, in Madison's words, did not eradicate religious conflict. Let me agree with Bishop Rhodes on that exact point, and so did Madison, right? But it sufficiently destroyed the malignant influence it could have on the health and prosperity of the state. Again, Madison's words. So in bringing religious liberty to bear on the conflict today, we are carrying out the original purposes of the First Amendment. And I say that because I think it's relevant to the judges who are here today. As we talk about sort of originalism and the history and tradition of our religion clauses, this is really one of the core purposes. How to relate that exactly to the originalism that the court is practicing today, that the Supreme Court is practicing today, is a complicated question that we could talk about in the discussion, but this is definitely among the core original purposes of the religion clauses, namely to mitigate polarization. Not the only, but one of the core purposes. I don't need to make the case. The book makes the case that we're polarized and that religious liberty is part of the polarization. I don't think I really need to reiterate that case here. I think it's kind of clear. But today I argue again, strong religious liberty. Strong religious liberty can again be a remedy for polarization. It protects people from suffering at the hands of the government for living according to their deepest beliefs. Protection from that threat today, too, can reduce people's fear, their resulting resentment, and their perceived need to suppress the other side in retaliation or anticipation. Protection of religious liberty, I argue, can do this function if it has three features. First, it has to be strong enough to allow people ample room not just to believe, but to live out their beliefs without fear of penalty. Second, it must extend to all religious views. Can't support only the groups with which you sympathize. Third, religious liberty must have boundaries that take account of other important interests. Now, putting together strong but with boundaries means that the devil is in the details. Much of the book is about working out some of those details. I believe that with careful analysis, we can have strong religious freedom and proper boundaries. So I make several arguments for strong religious freedom in the book. They're not the only arguments, but I try in the book to focus, as I said last night, on arguments that are most likely to reach persuadable people in the middle or even on the other side. I describe the importance of religious identity to people in their lives and communities. I have a chapter presenting the social science evidence on how religion, when it is free and voluntary, promotes the common good by benefiting individuals and enabling them, often through religious communities, to serve others. Also, to reach persuadable people in the middle as to the importance of religion for believers, I draw an extended analogy between same-sex couples and religious believers. That is, if you sympathize, and I'm speaking here to folks who sympathize with same-sex marriage rights and same-sex couples' interests. You should likewise sympathize with believers, including conservative believers, because their claims share certain important features. Both same-sex couples and committed religious believers seek to protect an aspect of identity that they believe is fundamental and pervasive in their lives, and in fact is. For same-sex couples, it's the multifaceted, intimate family relationship with a partner. For religious believers, it's the relationship of love and obedience toward the God who created and sustains the world. Second, both groups' identities are at best painful to change. No one can simply change their sexual orientation because the government says so. No one can change their conviction about God's will simply because the government says they should. Third, for both groups, the identity is closely tied to conduct. It was insufficient to tell gays and lesbians that they could marry opposite-sex partners or remain celibate. Insufficient for the government to say that. Not as an aspiration in moral exhortation and so on, but for the government to say, do that. It's also grossly insufficient to tell religious adherents that they can have their beliefs, but they can't act on them. And finally, for both groups, the conduct is not merely insular, but also public, socially apparent. Same-sex couples claim the right to live outside the closet, to participate in the civil institutions of the workplace and marriage and family. Religious believers likewise claim a right to follow their faith not just in the insular setting of the home or congregation, but in the charitable activity of their religious organizations and in their workplaces. As I talked a little bit last night, this analogy is aimed, not a perfect analogy, I wouldn't claim that, but there are enough similarities, is aims to cultivate understanding and even a degree of sympathy across ideological lines. Sympathy not, of course, for the other side's vision of sexual nonconformity or of sexual traditionalism, but rather for the predicament that the other person feels when faced with government restriction or discrimination. Because the features that make it a predicament for them would do the same for you. I want traditional folks to understand the predicament of same-sex couples and liberals to understand the predicament of Jack Phillips, the cake designer, or Laurie Smith, the website designer. Now, in making this analogy, I recognize that religious liberty alone then will not solve or fully address the conflict between LGBTQ rights and religious freedom, right? That involves a strong protection of religious freedom along with the recognition of the important interests on the other side. So my book contains a sort of extended argument for adopting and enforcing LGBTQ non-discrimination laws with strong religious exemptions based on the analogy between the two sides. We can talk about the details of that in discussion, if you like, where the line should be drawn on balancing those two. But I think it's important for the credibility and the future and the health of religious liberty claims to also make efforts to affirm the important interests of LGBTQ persons on the other side. Now, what that exactly means, I understand and appreciate the position that means you can affirm non-discrimination laws, but you can't affirm marriage. That's fine, but let's look for opportunities to affirm and protect the rights of LGBTQ people within the constraints of truth and as one understands doctrine. Extending the principles of protecting conflicting views, extending that from just the religious, the conflict between different religious views to the conflict between LGBTQ people and religious believers is, I think, an important part of the same project. Religious liberty is crucial feature of that, but it's not the only feature. Again, in drawing lines, the devil is in the details with respect to the protection for religious believers. I argue, based on working through some of the logic of this, that there should be very strong protection for nonprofit religious organizations, and protection of a lesser scope, but still protection for commercial vendors who provide wedding cakes and other situations like that. Again, we can say more in the discussion, and I'm very grateful to have this panel here because we've got three folks who have been working on the details of these matters, which I'm really looking forward to hear from them, and then enjoy engaging in the discussion. So thank you very much, and look forward to hearing from the others.
I think I'm up next. It's great. I'm very grateful to be here with Tom, and have admired his work for many years. Grateful to be here with Asma and Robin, with whom I've had the privilege of working. And thanks to Dean Cole and Stephanie for the invitation to be here. I've been thinking about this topic from my vantage point as one who has been involved in negotiations with LGBT groups and religious groups over the scope of religious freedom protections and non-discrimination. So I wanted to offer some reflections on depolarization just from the experiences that I have had. And I've written down a few notes here just so I could march through this rather quickly. I've been thinking about my friend Bill Evans lately. He died recently. For many years, Bill headed up the government relations team of the Church of Jesus Christ of Latter-day Saints in Salt Lake City. He was a warm and gentle man. Everyone liked him. Most of his work was in Utah, but in 2008, Bill played an important role in the passage of Proposition 8 in California, which, as you know, inserted the traditional definition of marriage into the California Constitution. With many other religious groups, the Church of Jesus Christ encouraged its members to support Proposition 8, based on its belief that the traditional definition of marriage is best for parents, children, and society. It saw itself as participating in the democratic process on a matter of legitimate debate and public policy. But of course, many gays and lesbians in California and around the nation saw Proposition 8 quite differently. They saw it as a denial not just of marriage status and benefits, but of equal dignity and citizenship. The anger and anguish were very real, and so was the backlash, especially against the Church of Jesus Christ. My old friend Bill was a peacemaker at heart, not a culture warrior. And so a few months after Proposition 8, Bill and a few other church representatives began quietly meeting in Salt Lake City with a small group of LGBT persons. They talked, but not really about politics or policy, at least not at first. Instead, they talked story, as Hawaiians might say. They spoke about family and friends, about common life and interests, about faith and love and tragedies and hope, about the ordinary things we all face in life. There are many truths in those kinds of discussions, too. The purpose of those early meetings was not to change beliefs or public policy. It was simply to learn and understand each other. Over months and years of these interactions, friendships grew, and so did understanding and trust. The circle of discussion expanded to include many others, including me. Bill eventually became close friends with the head of Equality Utah. In time, we learned to talk to each other about sensitive matters. As public tensions periodically arose, Bill and the head of Equality Utah would speak privately first to understand what had happened and what needed to be fixed or just lived with. The result is that differences and misunderstandings were often resolved without the media explosions and harsh rhetoric that were becoming increasingly common. Building on this foundation of friendship and trust, in late 2014, I began negotiations with Professor Cliff Roski, a top official at Equality Utah, about the possibility of adding LGBT rights and religious freedom protections to Utah's civil rights law, barring employment and housing discrimination. With the support from the church and tremendous work from my friend Robin Wilson and others, the ultimate result was the so-called 2015 Utah Compromise, or what Professor Bill Eskridge likes to call in his somewhat grandiose fashion, the Utah Statute of Principles. Final passage in the Utah legislature was uncertain. It was dramatic, it was intense, with each side stretched to its emotional limit. Opponents and supporters alike wept. Later, the jubilation at the signing ceremony was thunderous, with many hugging and crying. I'd never actually seen such an outpouring of emotion and relief. As a narrow legal matter, the law disappointed some, probably many, LGBT rights advocates. Utah's first gay state senator and a co-sponsor of the bill later complained that the law had not been used to generate more lawsuits. He was upset about that. In fact, I'm aware of its being used in any reported lawsuits, much less one against a religious organization. If lawsuits were the main point, then the law was indeed a failure. But lawsuits and legal conflict were not the main point. The point, it seems to me, and this is something that I came to discover afterward, was some combination of respect, equality, freedom, acknowledgement, inclusion, community, and compromise. The new law came to symbolize and to teach that. And the culture and rhetoric of this very conservative state shifted in response to the law. Not just the words of the law, but the process by which the sides had come together to enact it. Now, the church didn't change its doctrine on sexuality. Utah remains one of the most sexually conservative states in the nation, but it is also one of the most supportive of basic rights against unjust discrimination for LGBT persons. There are still periodic tensions and flare-ups, to be sure, but as a community, Utah is vastly less polarized than it once was, at least on this issue. Soon after the Utah Compromise, I was involved in a much more complex effort among conservative religious organizations and moderate LGBT groups to draft amendments to the 1964 Civil Rights Act that would protect both LGBT rights and religious freedom. We too began just getting to know each other, talking story, listening, and learning to get along. There were formal trust-building efforts like going on hikes together, and even shotgun shooting at one point, which, come to think of it, was probably a crazy idea. The starting point was a recognition that we disagreed on certain fundamental matters and that wasn't going to change. But also that as Americans, we agreed on many other matters, such as wanting a society that treats all people with decency and respect. And so we spent hundreds of exhausting hours in hotel conference rooms in big cities and remote rural areas. There were innumerable conference calls, Zoom calls, emails, negotiations dragged on for months and then years. There were plenty of deadlocks. Emotions and frustrations were sometimes high. There was yelling and tears, diplomatic outreaches, subgroups, apologies, and reconciliations. But there was also laughter and talk about spouses and family and friends and about things that had nothing to do with LGBT rights and religious liberty, except ultimately they did have to do with those things. We became friends and colleagues, determined to craft a fair solution to the LGBT rights, religious liberty conundrum, or at least one that was fair enough. With the grossly overbroad Equality Act looming over us, we soldiered on until at last we produced and got introduced the Fairness for All Act of 2019 or 2020. It was a huge achievement. The bill, with all its finely tuned compromises, is very long and complex, probably too long and too complex, almost assuredly. Almost everyone hated it. Powerful LGBT rights groups promoting the Equality Act denounced the bill for being a license to discriminate against LGBT people. Conversely, some conservative groups, many our dear friends, opposed it for including LGBT rights in federal law at all, and for not having broad enough religious exemptions. While it got some brave congressional support, it didn't pass, but neither did the Equality Act. So was all this a failure? No, it wasn't. The effort taught us to examine carefully what each side really needs, to prioritize our asserted freedoms and non-discrimination rights. Well, there are certainly fundamental interests and red lines. Not every freedom or non-discrimination right is of equal value. The effort taught us to be more practical and less ideological. It taught us to listen carefully and understand opposing views. It taught us to respect and trust each other in new ways and to communicate from a position of respect and trust. It taught us that we have much more in common than we originally thought, that we actually agree on most truths. Not all, but most. None of the religious groups that participated has changed its doctrine or belief about marriage, family, gender, or sexuality, or its expression of those truths. And none of the LGBT rights advocates has abandoned the quest for greater civil rights protections for LGBT persons. And yet, years later, many of us are still friends and in regular contact. Jesus Christ taught in the Sermon on the Mount, "Blessed are the peacemakers, for they shall be called the children of God." As one who is striving to be a disciple of Jesus Christ, I've come to see more clearly that efforts to promote a durable religious liberty must account for Jesus' injunction to be a peacemaker. If religious freedom is to be the means of human flourishing, as President Dowd mentioned several times last night, then it must be conducive to a just and livable peace among contending factions so that all may flourish. I believe that as advocates and scholars seeking to depolarize religious liberty, we would do well to keep that in mind. Thank you.
Thank you. Thank you to the Religious Liberty Initiative for having us here today and for you, for attending. This panel has been really interesting. There's been this sort of constant theme of hopefulness, the proposed solutions, the actual solutions. It's in deep contrast to some of the other things that we've heard this weekend and that we generally hear sort of pervasive in our society today. This idea that Americans are divided and the Supreme Court at the center of it all, especially in its controversial cases, is not only not making things better, but often makes things worse. And there's just no escape from this predicament. In fact, recently, Justice Alito was asked, what can the court do about polarization? And he confirmed this sort of really pessimistic take. He's like, I don't think it's something we can do. We have a very defined role, and we need to do what we're supposed to do. This is a bigger problem. It is way above us. However, some of the recent things that I've been looking into suggests otherwise. I've been looking at the intersection of legal theory and social science to determine ways that we can actually, and specifically not just we, but also the court, can write about things, can speak about things in a way that helps to lower the political temperature. And I look to social science because I think often we have a lot of theories about what works, but social science actually tells us what actually works. It tells us how humans think, what motivates human behavior, what changes the way people think about things. And we heard about this a lot yesterday, especially in Professor John Nazu's panel, about this idea of language and how just learning how to disagree, that really matters. And my research says that it's not just about how we as Americans or as everyday citizens speak to each other, but again, how the court also speaks, even in cases with outcomes that people have deep disagreements about. So my own research takes as a starting point a model of constitutional pedagogy that was developed by the legal scholar, Professor Christopher Eisgruber. And he was writing in the early 90s when he kind of talked about the court as an educative institution. How does a court fulfill its sort of original role as a schoolmaster? Because the founders thought of the court as a Republican schoolmaster. The early justices used to sort of travel the nation and used to teach citizens about the ideals of the civic virtues and the ideals of the new nation. And how does a court play that role today? And so he has a three-part model. He says the court has to start by establishing community with its audience, particularly the audience that is most likely to disagree with its ruling. It needs to identify a shared trait, something that the court shares in common with these people. Then it needs to probe the principles underlying the trait. And then it needs to redefine what it means to actually hold that trait, right? Like if you truly believe in this, you actually would agree with what we're ruling here. And so he offers a number of examples. One of the examples is West Virginia v. Barnett, that involved Jehovah's Witness children who did not want to salute the flag and recite the Pledge of Allegiance. And this was deeply offensive to Americans who are patriotic. At the time, it was a very sort of contentious issue. And it was like, well, of course everybody has to do this. This is what it means to sort of engage in this in sort of national unity. And engaging in the ceremony is key to that unity. And the court says, we agree that patriotism is really important, right? Establish the shared trait. We, like you, agree that patriotism is really important. But what does patriotism really mean? What does Americanness really mean? Is it this sort of like rote, lockstep adherence to ritual? Or is it about a shared respect for individual autonomy? And then the court says, well, it is, and sort of widens the scope of this trait and said it's really about this sort of shared respect for individual autonomy, the freedom to think, and hold your own beliefs. And look, what we're doing here is we're upholding the most ideal version of Americanness when we uphold the right of conscience for these Jehovah's Witness children. So I was reading this legal theory, and I was like, it seemed intuitively right. Again, it sort of touched on the ways that we sort of talk about things in a way that creates community and common ground. And I also thought about how recent findings in social science support these findings, but also support the model and also build on it. And so I turned to social science as a way to sort of root this model and sort of give it empirical rigor and root it in actual data. And my starting point is procedural justice research. This is a really well-established body of legal scholarship that has found that when, we're looking, and there's been a number of studies looking at police-citizen interactions, and it found that when people perceive the police as fair in their procedures, they were significantly more likely to comply with the law, cooperate with legal authorities, and engage in community policing partnerships. Really key to this was 4 key factors: neutrality, the extent to which authorities are seen as unbiased and objective; respect, whether they treat people with dignity and respect their rights; voice, which is giving them the opportunity to tell their side of the story; and trustworthiness, perceptions that authorities are benevolent and sincerely motivated to do what is right. And it didn't matter what the outcome was. People still thought, even as they were being arrested or being penalized in some other way, that these authorities are worth respecting because we have been treated fairly. Building off of that, I've turned to cultural cognition theory, another sort of body of legal scholarship that looks at how cognition sort of comes into how we understand law. And this body of scholarship focuses on how people tend to interpret information in ways that conform to their cultural worldviews, something that we understand as motivated reasoning. We see facts, we see what's happening, and we interpret it in wildly different ways depending on which particular sort of informational echo chamber we exist in. And there are a couple of strategies that this body of scholarship suggests. One of them is affirmation, this idea that if you just tell people that fundamentally we affirm who you are, and again, based on a whole body of social science studies, that if you actually first communicate to people something really positive about them, they will be a lot more open-minded and less defensive when you tell them something they disagree with. And the second one is aporia. Aporia being this expression of uncertainty, that the court understands that there's something really difficult here, and it doesn't have a sort of black and white take on it, but instead the court very explicitly is engaging and struggling with this difficulty and looking at both sides, even as it comes out with a definitive decision. And so we saw a little bit of this affirmation technique happening in Obergefell when the court made it a point, even as it upheld the importance of same-sex marriage, to also go forward and state very explicitly that those who disagree on the basis of decent and honorable religious and philosophical premises are not disparaged by the opinion that the court is thinking about them. And I think the court could have done more. It could have sort of extended out a lot of that affirmation. But the fact was that people were still very upset by the opinion. But it's also a fact, as we see even here today on this panel, that that language was the inspiration for so much bridge building and sort of compromise work that came after. And then the third sort of piece of my social science or like puzzle here is moral foundations theory. I think a number of people here might be familiar with Jonathan Haidt and his research about people's gut level reactions to controversial issues. And he has noted that there's 5 core moral foundations. There's the harm care foundation, which is about caring about others and preventing suffering, being compassionate. There's the fairness reciprocity foundation, which is about treating people fairly and equally. In-group loyalty, which is about protecting your own and kind of being wary of outsiders. Authority respect foundation, which is about respecting tradition, following rules, preserving order. And the purity sanctity foundation, which is about avoiding dirty or disgusting things and being spiritually pure and wholesome. And Jonathan Haidt has found that liberals prioritize care and fairness, whereas conservatives tend to prioritize all 5 moral foundations fairly equally. And it kind of occurred to me that if the court, again, in these really contentious cases, including in religious liberty, is concerned about how people who disagree with it, oftentimes along the liberal-conservative divide, how do you appeal to them? Well, appeal to them through the moral foundations that you know resonate with them. So if you know liberals are going to disagree with you, touch on the harm care and the fairness reciprocity foundations. And so just briefly, I started thinking about how this would work in various past cases that I knew to be extremely divisive. One of them is Roman Catholic Diocese v. Cuomo, hugely controversial case. It involved challenges to COVID-related restrictions on religious gatherings, and the court ruled in favor of the religious organizations. Now, the court struck a confrontational tone, stating that even in a pandemic, the Constitution cannot be put away and forgotten. It framed the case as a clash between religious freedom and public health, asserting that the regulations strike at the very heart of the First Amendment's guarantee of religious liberty. There was something about this language sort of failed to take seriously the sort of deep concerns of those who were genuinely concerned about public health and the way that this would impact public health. I mean, full disclosure, I agreed with the court's ruling, so that's not the issue here. It's really just about how is the court communicating this to people who were going to disagree with it, and he knew that, and the court knew it was there would be these people. And to frame these objectors as merely sort of out to get religious beliefs, as sort of setting up an us versus them attitude. Now, if you were to employ some of the strategies that I've just outlined, what would the court's rhetoric have looked like? Well, first, the court could have established community with the audience who prioritize public health by explicitly praising, affirmation, its ethics of compassion, self-sacrifice, and concern for the collective good. It could have explicitly affirmed this unwavering commitment to alleviating suffering and upholding human dignity. And then it could have redefined it to show that the best version of the trait is a version that recognizes that those who turn to communal worship as a sign of light in deeply dark times, that this is also a way of serving the vulnerable, right? Talk about these religious communal worship as an essential service there, again, to help people who are suffering. And by doing this, the court, again, taps into the harm care foundation, that what's really motivating these people is a concern about the vulnerable, and we're going to tap into that and to make our own case, and to show if that's really what you're worried about, then you would agree with this ruling. So again, my work is really about kind of pushing against the pessimism, saying that there are strategies out there that are supported by data, and that there are practical steps that the court could take to be a bridge builder, including in very controversial cases. Thank you.
So I just want to thank the Notre Dame team and Professor Barclay in particular for putting this together. I look across this room and I see so many people I admire, not least of which are the folks at this table. So it's a privilege to be here. I have called this talk, Religious Liberty in a Polarized Age, the happy account. And so I'm going to focus on that in just a moment. But I want to say congratulations to Tom on his book, especially coming at this really important juncture. So it does feel like our system is broken. Only a third of us say we find conversations with people that we disagree with interesting or informative. That's down from half of us in 2016 finding that useful in some way. 8 in 10 of us think political debate has become less respectful. I think probably, I don't know why that's not 10 in 10, but there we are. And my students, this is the thing that really caught me. They tell me they don't date across political lines, just won't do it. And that's something that 40% of Democrats, 48% of Republicans, and 49% of independents are very happy just to report to people who call them in a survey. So yeah, we are retreating across ideological lines. We are huddling in our tribes, as Bishop Rhodes noted. So no wonder that the 3 words that Americans most use about politics are divisive, messy, and polarized. Now, that said, the happy account. There are success stories in the middle of this fracturing. So for example, state-level Religious Freedom Restoration Act, or RFRAs, have roared back from the dead. The Federal Respect for Marriage Act passed with bipartisan support, giving religious liberty protections in red states that they did not have around marriage. Now, I think what should intrigue us is how these bipartisan moments are co-created in the midst of this train wreck. And I want to suggest that there are, here I'm going to borrow your word, 3 guideposts. I had tenets, but you're right, it's not a tenet, it's a guidepost. 3 guideposts have supported lawmakers who have sought and have protected religious freedom and religious liberty while combating polarization. They did both things in these laws. So the 3 guideposts are: first, any deal has to strive to take people out of positions of conflict. Second, lawmakers should strive not to take back rights while pursuing the creation of others, or the clarification. Third, and arguably most important, laws should protect people in equal measure. So I'm going to touch on each of these quickly, and I'm watching your time. You scare me. Okay, so what do I mean about taking people out of positions of conflict? This famously happened, as Elder Dushku described, in 2015, working on behalf of the LDS Church across lines with LGBT advocates. And what they did was mesh the interests of people of faith with those LGBT persons who wanted nothing more than security from discrimination in housing and hiring. Now, in most contexts, it should be irrelevant who somebody loves or how they identify. Not every context, not in the house of worship, but in most. So the result, the Utah Compromise, which gave more protections to the full LGBT community than that community had at the time in New York law. And it gave more protections for people of faith around marriage, faith, and sexuality than any state in the country then and today. Now, not to make a pun, but the lawmakers in Utah married the interests of both sets of stakeholders in the same law. And that happened again in the Respect for Marriage Act. It gave the red states the religious liberty protections that states that had voluntarily enacted same-sex marriage had put in their own state marriage laws. Of course, the red states have it given to them by a Berg, so they don't have these laws until the Respect for Marriage Act. But that act also gave LGBT couples assurances that their marriages would not be undone. Or more technically, they would be valid everywhere if they were valid where they were entered into. Now, the interests of religious conservatives could be protected, as it turns out, without leaving same-sex couples afraid that their marriages would be taken back after Justice Thomas's concurrence in Dobbs. And people were afraid. Now, these stakeholders did not need to be in positions of conflict. They both could be served by the same law. Now, these laws are not one-offs. In fact, the ethos that Elder Dushku described has been carried through a number of laws. For example, in 2023, Utah unanimously enacted an adoption law. Now, we know adoption and foster care has been a hot mess. We have agencies that have been threatened to close or have closed. We have couples who wanted nothing more than to adopt a child who have been turned away. That's a hot mess. What does this law do? Under this law, no qualified couple, gay couple, is turned away from a religious adoption or foster care agency in Utah. And no religious adoption agency that wants to follow its convictions, say, for example, about which families to certify to adopt, none of them are forced to close. The law did this by placing all adoption agencies that serve Utah residents into a consortium. Every qualified prospective family knows that there is an agency within that consortium to serve them. The state has an obligation to make sure there is. And the consortium guarantees every prospective adoptive family gets the respect and the help that they need when they are asking to take a child on behalf of all of us. Now, this law took people out of positions of conflict by respecting the interests of both sides to live authentically according to their beliefs. Now, second guidepost, no takebacks. Now, many of us are going to recall sitting here in Indiana that 2015 Indiana RFRA that was tagged as rolling back the rights of LGBT people, right? Everyone from Tim Cook to Rihanna said it. Must be true. Now, they said that this would mean that Indiana businesses could deny services to LGBT people under the guise of religious freedom. So what was the result? A carve-out for civil rights inserted into Indiana's RFRA, which I think is very, very bad precedent. Now, we know this narrative is more complex. Then, as now, Indiana has no statewide sexual orientation, gender identity, non-discrimination law that RFRA would have undercut. Although municipalities like St. Joseph, where we're sitting right now, do. I think we're in St. Joseph anyhow. Okay. But that tag stuck. It made RFRAs toxic. For 6 years, no state passed a new RFRA. That year, Utah enacted what is this year, Utah enacted what is arguably the strongest RFRA in America. One key, making sure that the carefully constructed bipartisan legislation like the Utah Compromise, the adoption law, and the unanimous 2023 ban on gay and trans conversion therapy that Utah enacted last year, that none of that would be undone by RFRA. The bill sponsor, Senator Todd Weiler, added whereas clauses expressing his and the legislature's intent not to disrupt the delicate balance that Utah struck in these laws I've described. Now, true, those clauses don't bind courts. They don't have that legal effect. But if you don't mean to do something, giving assurances to people is often a good idea, and it can bring unanimity. Now, the third and final guidepost, protect people in equal measure. And here the happy story I want to tell is about Utah's novel 2024 law, which just became effective, that protects moral conscience in the workplace in addition to religious conscience, and it does so expansively, taking pages from Groff. Now, Utah's Constitution protects rights of conscience in addition to religious freedom. It appears to be alone among the states in doing so. This new law gives substance, though, to this guarantee in the Constitution to government workers in the workplace. And these workplaces have been infected with cultural war battles and hurt real people. You see that in the news every day. But as one example, in Texas, librarians have been forced out of jobs they held decades because they didn't want to take books off a shelf. Somebody else could have taken the book off the shelf. It could have been staffed around that specific task. Also, as a more close-to-home example in Utah, famously, the year before the Utah Compromise, a motorcycle cop was forced out. He quit when he asked not to be the person at the head of a pride parade that had to perform celebratory maneuvers. He asked to be staffed around. He felt that these actions would make him a spectacle like being afloat in the parade. And he would be seen as endorsing a particular message, maybe one that he doesn't share. And this officer secured a trade with another officer, but the department decided that they weren't going to allow that, even though they had allowed officers to take time off and be staffed around to propose, or for other personal reasons. Within a week, the department chief said the unnamed officer had refused to protect gay people. He did not. He had offered to work security. And that chief said that this department would not tolerate officers who, quote, expressly, outwardly expressed bias. So they tagged him a bigot for his conscience claim. Now, like Gerald Groff, the department easily could have staffed around Officer Mutso's respectful claim of conscience. Utah's new law makes employers provide a reasonable accommodation up to an undue burden. Now, the employer's off the hook for all kinds of reasons. We can talk about the boundaries around this right. But in particular, if staffing around him would result in a substantial increase in the cost of their operations. Now, although this law is cut from new cloth, Utah's conscience protection for government employees succeeded because it is agnostic. It protects conscience claims emanating from progressive commitments as much as it does from conservative commitments, as much as it does from anybody's idiosyncratic view of what they can and cannot do. So it protects people of all convictions in equal measure. So I'll stop here by saying lawmakers can successfully thread the needle of protecting religious liberty at a time of great polarization by choosing not to polarize religious liberty. Thank you.
So I think we'll have a few minutes for discussion amongst the panelists, if there are any questions or responses you wanted to offer to each other, and then we'll take maybe just one or two questions from the audience before we close.
Well, let me just say, my sort of off-the-cuff flip remark about Mark Twain and the weather and polarization was untrue, right? What you've heard up here is just a wonderful example of all the different ways in which it's possible to draw lines, to balance interests, and also to advance understanding at the same time. So there are a lot of people doing stuff about reducing polarization in this space, and I'm very glad to have been associated with with all of these folks. So thank you.
Thank you. I wanted to make one comment. We actually, here in this room and in other gatherings that are like this, we actually know a lot about depolarization, because if we didn't, we wouldn't be sitting in the room together with each other, because we come from many different faith traditions, which in times past meant that we would be killing each other. But we don't. And not only do we not kill each other, but we sit together and we eat together and we have friendships, and in doing so, we cross lines that in times past we would never cross. And that is actually extraordinary, and we ought to pause and recognize that. And it's extraordinary as a historical matter, but it's also extraordinary as a matter of just friendship and relationship building. And so I'm optimistic because I think we know how to do this, because we've already done it. Talking to people, interacting with people, loving people, breaking bread with people who have fundamentally different beliefs about many things, but not about all things. And there's enough left over that we can sit down and talk. And that includes, I believe, virtually all Americans, and perhaps even beyond. So I'm optimistic that we who've been advocating for religious freedom have the tools to be able to bring about peaceful resolutions, hard fought often, but nevertheless peaceful resolutions that work well enough.
I don't have anything.
Why don't we go to questions?
Sure, great. So let's collect a few questions from the audience. Please use the microphones if you're able, and then we'll do a collective response to those questions.
Good morning. Thank you so much for what you offered and your comments and the work that you're doing on this topic and talking about something that is a very sensitive topic for a lot of people of faith. My concern is the way in which it was framed, that it was framed by almost every presenter in talking about religious people and LGBTQ people, as though there aren't LGBTQ people that are religious. And I specifically state that because there's been data that was done, research that was done by the UCLA Williams Institute that found that 5.1 million people that identified as LGBTQ are religious. At the same time, when you look at it in terms of Black Americans that identify as LGBTQ individuals, over 71% of those individuals identify as such. So for me, it's a concern where we're pitting groups against each other in that way to say that LGBTQ people do not have religious beliefs or identities in which they hold as sacred as people that do not necessarily support that. How are you working to address that framing within your own individual context to make that so it's not, so people don't do that? They don't create more tension between those communities. Because I think if we're going to do the work of depolarizing this issue, we have to look at the both and of it.
I'll take that. Tell me your name.
Is Dr. Sabrina Dent.
Okay, thank you, Dr. Dent. I think you're exactly right. There are people who straddle, and God bless us, right? Because then we have folks who understand each set of interests. It can be really, really hard in this space to try to drop that footnote, okay? In my papers, I'm usually pretty religious, not to make a pun, about saying that somewhere, because I think it's really, really important that this group, and I didn't realize it was quite as large, I'm going to go back and look at the Williams Institute, that this group can kind of see both pieces. I think we dangerously shorthand in a different direction too, though, so I want to make a follow-on to your point. Not every religious person is not down with LGBT rights, right? So what we're always talking about in the culture war are the tails, okay? I personally believe the great swath of Americans are like, why are we fighting about this? What are we even talking about, right? So we are always capturing tails, but you're right, if we could focus on the middle, and especially people who are parts of both communities, then I think we would profit ourselves.
Thank you. I appreciate that. Because as a person of faith who also worked on mobilizing people of faith around the Equality Act, it's important that we see this. So thank you.
Yeah, can I just add, Dr. Dennis, thank you. And I would say exactly the same thing. I put that acknowledgement in my writings, and it's simply a matter of just kind of not having said it in the very short time that we had here to make that point. So I absolutely affirm what you're saying about that. I think the only point that where there's a difference is that the LGBTQ claims do not depend on being religious. So in that sense, their claims about family, that may be deeply intertwined with religion for many folks. Their claims about family and autonomy and relationships that don't depend on being religious, whereas the religious claim is just kind of conceptually different. But we shouldn't let that difference make us gloss over the point that you're making, which I think is absolutely right.
Thank you.
Thank you.
Good morning. Thank you. I'm Jim Rice on the advisory board. I'm curious how a couple of you would react to how social media either encourages or frustrates the kind of concept of talking with each other and breaking bread together and getting to know each other, because it seems to me that vehicle in our society now creates some difficulties.
Yeah, I mean, I think it's a well-known thing at this point that social media, sort of like you develop your following by just being the most extreme you can be, right? The more inflammatory, the more followers you're going to get, and so it sort of incentivizes people to sort of make things worse. I mean, I think in the context of my own research, is the thing that I was talking about in terms of the Supreme Court's rhetoric. I think that's like often a sort of counter to that. Like, who cares what the Supreme Court's saying if people are just going to distort that in the way they sort of tweet about it or post about it on X? And well, one, it doesn't take the sort of responsibility away from all of us, including the court, but each and every one of us to continue to frame things in the right ways, in ways that are inclusive and affirming. And I think there's also evidence pointing to the other side, that when the court does engage in this sort of this type of rhetoric, the type of things that I was suggesting, where it can makes it a point to acknowledge the important concerns on both sides of the divide. Some of that also gets reported on. I mean, that also makes it out there. It's still fighting against the sort of wave of extreme sort of black and white portrayals, but that rhetoric also does make it out there. And so the more we can continue to sort of like flood the space with productive rhetoric, I think the increasing sort of likelihood that that's going to make it out to the masses.
Maybe another response as well. Social media, which I think I've posted one thing on Facebook my entire life. Okay, I have no interest in it whatsoever. But it's a powerful force, and obviously it's all around us. It gives people the luxury of having opinions and stating what they think to be truth, disembodied from the actual context, human context in which truths have to exist, and that's why it's important to get in the same room and to shut the doors and to turn off the phones and actually talk to people and to look at them. And you may not ultimately agree at the end of the day, but at least you have an understanding of what another human being is trying to say and is living and is going through, whether the person is religious, not religious, LGBT, combinations of all of that, as Dr. Dent pointed out so importantly. It strips you of the luxury of just sort of speaking into the void with abstractions that may or may not really hold in the context of an actual human being in front of you. Or if they do, you may have to own the stark realities of the truth you're asserting in the face of a human being who's in front of you. It's just a different situation. And I think social media, for all the good it can do, is enormously destructive of the kinds of interactions that we need in order to figure out how to get along together and live together and be united together.
Asma, can I ask you a question? I sometimes think that maybe the current court doesn't get enough credit for efforts that its members do make to do some of the things that you're talking about. I think about several Justice Kavanaugh's opinions in some of the most controversial cases. He often writes a concurrence that says, I join, this is right, but let me explain further, let me take into account some of the arguments on the other side, what are the consequences of Dobbs, and it's not going to lead to this and that. He seems really concerned with making those kinds of points. And even in the 303 creative case, that was, more kind of like the reaction to it was more negative than the reaction to the Masterpiece Cake Shop case. Justice Gorsuch goes out of his way to say that public accommodations laws are here, they serve an important purpose, and affirm that side of the equation in a really direct way. Now, maybe some other parts of the opinion suggest that you might have very broad challenges to public accommodations laws, maybe a little bit loose, but you could argue at least. But would you say overall the current court is making credible efforts to carry out some of these rhetorical ideas, responsibilities?
I mean, I think the answer to that is it depends on, often even sort of like it depends on the context and topic. So in one of my papers, I've looked at what the court was doing in its number in sort of Masterpiece Cake Shop and Fulton v. City of Philadelphia, and showing that in the context at least of these LGBTQ religion cases, to the extent that they're in conflict there, the court is making it a point to sort of recognize both sides, seems to be engaging in some of the social science strategies that I have identified. But in general, I think that it is true that some members of the court are really concerned about the legitimacy of the court and have taken steps toward that end. But I do think that in the vast majority of these controversial cases or highly culturally salient cases, the court doesn't really know how to do that. I mean, you can sort of add this language, but the social science actually tells you what type of language, what sorts of foundations to sort of tap into, what is actually effective. Again, sort of they're functioning on the basis of like, well, if we add this particular language in the concurrence, even if we have a really inflammatory majority opinion, that's somehow going to walk things back with people and make the reaction somehow less inflammatory, less inflamed. But I think that's where a lot of sort of the nuances are there. What are the strategies? How do they work? What does it work if you have a dissent that's in sharp contrast with the majority, a concurrence to try to do some of these things even when the majority doesn't care? A lot of those sort of, the solutions are in the weeds.
Please join me in thanking our panelists.